lawyer question you get all the time.
In this moment, the question that I get a lot is pretty broad. It's, is that legal? So a motion to intervene is there's already a lawsuit happening between parties, and then you're coming in or intervening because you think that your rights are affected. So as an intervener, you step into the case, either defending or prosecuting, whichever side you want, but you're stepping in to defend your interests that the other parties aren't protecting.
The easiest way to think about civil rights are the various rights that allow people to engage in society. Think about rights relating to work, to voting, to being out in the world and having access to all sorts of places. But there are a lot of constitutional rights that aren't quite civil rights and really aren't thought of that way. That could be the Second Amendment. That could be the Third Amendment. Nobody really thinks of the right to not have government soldiers quartered at your house as a civil right. But I think the best way to think of it generally is civil rights are the rights that guarantee everybody has the ability to engage in civil society.
En banc, fancy French word. So if a party loses at a district court, they can appeal it to the appellate court. And usually you get to talk to 3 judges at the appellate court and make your case to them, and they decide it. In really special circumstances, the whole appellate court will hear it. So it'll be 12 or 15 judges, all the active judges in that circuit court. And they do that in situations where the case law is undeveloped or it's being applied to a totally new sort of novel set of facts. So for en banc, you've got all the judges and plaintiffs make their case to them.
A motion for summary judgment is what we call a pre-trial motion. So this occurs before a trial ever happens, and it's a step that a party in a case can take if they think that their case is so strong that regardless of whether all the facts weigh in favor of the other party, you are going to win. So it's essentially a step to save both parties and the court from going through an entire trial and litigating everything.
It's kind of a big question. The First Amendment protects a lot of things. The idea being largely that the government has to stay out of your business when it comes to the practice of your religion. There's the freedom of speech, freedom of the press, freedom to peaceably assemble, freedom to petition the government for redress of grievances. And then there are some parts of the First Amendment that aren't actually written into the First Amendment. So there's the freedom of expressive association. And the Supreme Court at a certain point read that into the First Amendment, the right to gather for religious worship, or the right to gather at a union meeting. And then there's the right to intimate association. And that's the right to, choose your family, to have these very personal, intimate relationships and not have the government be able to step in and determine what those relationships are like.
Judicial review is one of the core tenets of the checks and balances in the constitutional system. It's the concept that the courts can review the other 2 branches of government, the executive and the legislature, for constitutionality.
I'm Bradley.
I'm Anne.
I'm Andrew.
I'm El Shaddai, and this is Ask an Attorney.